into today's session with some questions and definitely interested in the content. So, hi everyone, welcome to the 2024 Mid-Year Labor Law Update, today sponsored by Monterey County Works. My name is Anna Manzano. I'm the Digital Media and Event Strategist here at the California Employers Association. Before we officially get into today's content, I have just a couple details to cover with you. So as you see, your audio is muted for today's presentation, but there's going to be lots of opportunities to engage during the session. If you have questions pertaining to today's content, you can put those into the Q&A box at any time, and we'll try to address them as we go. We are lucky to have two trainers today, so while one is delivering the content, one will be managing that Q&A. I'll be over in the chat box if you have any technical issues, but try to direct your questions to the Q&A because then we can really keep things organized and make sure you get what you need. Okay, cool. Handouts for this training, those were sent out in yesterday's reminder email. However, I'm also going to drop them into the chat box. In just a few minutes, you'll see a little file icon pop up. If you just click on it, it'll download locally to your drive. And if you have any questions, just ping me and I got you. Last but not least, we do have a survey. So because your feedback is so important to us, please, if you could take the 60 to 90 seconds to complete the 5 questions at the end of today's training. We take the feedback that you share with us to heart. We share it with our partners over at Monterey, and we collectively just make sure that we are meeting your expectations with trainings like these and our entire suite of resources. So we would really appreciate you answering those 5 questions at the end. And now I have the great privilege of introducing our trainers today. We have Juliana Gabriel, who is our HR Compliance Director, and Astrid Servin, one of our HR Directors. So whether you're a CEA member or have called into the Monterey hotline, maybe you have worked with one of them before, and hopefully you will in the future. So I know we have a lot of ground to cover. So ladies, it's all yours.
Thank you, Anna. I love your energy, Anna. I love it. It's contagious. So ready to start this mid-year labor law update. Welcome, everyone. I see some familiar names out there. So nice to see everybody here from Monterey County. We're happy to be here with you. Juliana's going to take over the second half. I'll take the first half of this mid-year labor law update. We're excited to present this information over to you. We have quite a few updates. Even though we're only halfway through the year, we already had some changes. California never disappoints. So we're excited to get going on this. But before we do, I just want to tell you a little bit, remind you of Monterey County's Workforce Development Group and all the things that they offer for you all. So please engage with them. This is a great service that they provide for you in terms of recruitment, when they have those fairs for you to go to, training that they provide, which is wonderful for service for your employees or prospective employees to have, resources and other services. I always say tell a friend, because this is great information provided to you for free with the county. So lots of services, and one of the wonderful benefits you get is this employee hotline with webinars such as this one. There will be other webinars coming up as well, so please keep in touch with Monterey County's department here. You could always call in to our hotline and we will answer one of those between 8 and 5. Answer any questions through the employment cycle. So anything from onboarding or pre-onboarding all the way to the termination stage. So if there's ever any issues, concerns, you just want to, hey, talk it over with another HR professional. What's going on with this? What should I do? Please give us a call. And again, tell a friend, a co-employer in the county so that they know and they're aware that this service is around. You can always talk to Laura Kirshner. She's a wonderful contact. Her email and phone number are here, and her email website here. So if you need anything regarding Monterey County's works and the way they support businesses, please contact them. And we look forward to hearing from you when you call in as well. A little bit more about our company. We are an HR consulting company, and if you find yourself needing a little extra support in addition to what Monterey offers and what the hotline offers, you may want to consider joining us as a member. And I know I see some members already on, so that's wonderful. We like to say we provide peace of mind to employers out there with our HR services. So we do everything from, we help with recruiting, we help with training your management team. We have a wonderful lead program that trains supervisors and managers for 6 weeks. We have an HR 101 series where we provide support for HR professionals who may be starting out or who need a refresher. Very unique to California. So even if you're out of state and needs that extra support, we provide that. So in addition to that phone support, again, we have those on-site trainings, Zoom trainings. We have a lot of templates. So why reinvent the wheel? We have a lot of templates and forms that you can use, some guidelines, some fact sheets on all the various laws in California, as well as other unique things that may come into play, such as drug and alcohol in the workplace. So things like that. We offer even union avoidance, union labor relations. We have that as well as lots of partners that partner with us for a lot of times discounted rates. So and visit us at employers.org. If we have time at the end, Juliana may just visit the website, and there's a lot of free resources for employers as well. So even if you're not a member, go over to employers.org. There's a section there under HR forms called CEA free resources for employers. So let's get going. What we are not is a law firm, so we do not offer legal advice. We do have partners who are lawyers. So if you need that legal advice, we do recommend some lawyers there on our partners page. But this presentation should not be relied upon as legal advice. This is educational and we want you to learn from it, but consult your own attorney for anything that's of legal significance. It will be privileged and confidential when you talk to your advisor legally. So what we're going to cover today, the objective is to kind of go over all the latest things. Here we are mid-year. There's some wage and hour updates because in July we get some areas in the state that decide they want to increase the minimum wage. So we're going to discuss which cities, which areas increase their minimum wage. And you may have heard of a little thing called the Workplace Violence Prevention Plan. And not so little, right? We're in time right now. We're still in June, but come July 1st, this is going to be enforced and take effect. So it's a new law that passed in January that is implemented and it takes effect in July. So we have a few more weeks to get compliant. We're going to review and go over some of those steps. We've gotten to know it a little bit better, and we will also tell you how CEA can provide some resources and support for you. And then we also have a change in normal for labor law updates for CEA. We typically always talk about California, but there is a federal law that came into effect, new rights for pregnant workers, and Juliana will discuss those because some of those, although they're federal in California, typically provides more restrictions when it comes to laws, leave laws. This one has a few nuances we got to discuss. And so some things that will come into play for California that you need to be aware of. And then we have some industry specific rules that may or may not apply to you depending on the industry that you're in. However, we should still pay attention to them because when one industry adopts something, it typically is the case that other industries will follow and then the state will follow. And you know, California is a trendsetter, so we'd like to start in one small area and then expand. So we'll look at those specific rules and go and see what you need to pay attention to. And then at the end we have, and actually throughout our presentation, we have some FAQs. We find that sometimes that helps employers when we give kind of some real world examples and then answer those questions. So stay tuned for those throughout the presentation. So let's begin with wage and hour because our employees do not work for free. We have to pay them. And so we need to talk about money and we need to talk about paying them correctly. So for 2024, all employers now in the state of California have a minimum wage of $16 an hour. And in certain industries that may be more, and we'll talk about those later in the presentation. But for right now, for most employers, we're looking at $16 an hour for your hourly folks. And then exempt employees, no matter where you are in the state, the exempt will be $66,560 because for exempt salary, we follow the hourly. Except for one little industry, and that's that fast food area. That might be something that's a little bit different, and Juliana may spend some time talking about that. But you may find that 66,560 is quite high. Maybe we're in an area where we want to have somebody be exempt, but we just can't pay that. And so maybe we want to keep them hourly, and that's okay. You can always keep an employee hourly, or maybe you're looking ahead to 2025 and seeing the increase that's coming ahead. And so you're going to maybe leave your employee as now hourly, maybe transition them back to hourly. So we do have a little fact sheet here how to transition employees back to hourly. I was just working with the company on that. There is a few tips just to remind your employees who may have been exempt for a very long time that now they have to keep a timesheet, they have to track their meal periods and their breaks, they have to track overtime and just kind of get used to the mindset of being an hourly employee now. So just a reminder on that. And then now we're getting into the local minimum wage because there was an increase to quite a few. There's over 40 local ordinances that apply throughout the state. So if you have employees that travel frequently who are all over the state, you need to pay attention to that minimum wage of where the employee is actually performing work. There also could be things such as sick leave and predictive scheduling, especially if your employees are going into the Bay Area. That's something that is in that area known to be there at predictive scheduling and some flex time. The local minimum wage is based on, again, where the employee physically works. So if they're working from home or if they're traveling and spending more than a couple hours in that municipality, you will have to follow those increases. And that a lot of times when there's that minimum wage, the sick leave will follow as well. So here are the local increases on July 1st that you need to know. And if you actually have employees working specifically in one of these cities, just put it in the chat. Juliana's ready to and prepared to put in there what your minimum wage is for that area. Or better yet, go into the bit.ly if you want to go and follow this link that we've provided here on the slide. You can actually go straight to that fact sheet that we have that's free for employers so that you can see what the minimum wage is, because there were quite a few increases in Northern California and Southern California, and they tend to pass every July 1st. So please follow that instruction there, that information there. Juliana?
Can I pop in with a question?
Yeah, of course.
So a question that has come up is if you have a salaried person and they're kind of working on more of a part-time basis, you've given them some flexibility, can we prorate that 66,560 at all?
That's a great question. And no, you cannot. So an exempt employee is exempt from the wage and hour laws. It doesn't matter how many hours they work. They're presumed and we want them to work a 40-hour schedule. That's what we typically think of as a full-time employee. But if you have a lower schedule, you just want them to come in 30 hours, but you are coding them as exempt, then you'd have to pay them the minimum of that 66,560 amount. Anything
And
else
that's
you want to
always
add?
No, just that that's always tied to the state's minimum wage. So 2 times the state's minimum wage times 28 hours. So every time the state's minimum wage goes up, we see those exempt salaries increasing. Luckily, not tied to the local minimum wages, or it could get really crazy.
And
And I
really
just,
tricky.
uh-huh, yeah, tricky to track that too. And I wanted to mention some of the higher ones here on this list. San Francisco, Berkeley, they're up to 1867 an hour
Wow.
in terms of their local minimum. So I think we're going to see these pushes towards that $20 an hour minimum wages in
Mm-hmm.
the next few years. But I will go to the chat box. Looks like we have a couple questions on local minimum wage, and I will answer those.
Great. Thank you, Juliana. Yeah, and keep those questions coming. That's what these trainings are for. We want to try and get as much clarity as we can, or get back to you if we can't answer it right away. But yeah, pushing that $20, and many employers are doing it already just to remain competitive out there, to be able to recruit employees out there. They're doing it already. So here we get to our question. This is kind of changing and going towards a different area here, but before our employees start their day, we have a security screen process. Employees must scan their badges and go through a bag check, a metal detector. The process is about 5 to 10 minutes each day, as a line often forms. Employees then clock in to start. Is this okay? Well, we have a new case that kind of answers this, and so it says probably not. So the 2024 case is the Huerta versus CSI electrical contractors, and this is another reminder that employees should not be engaging in pre and post shift work that is off the clock. So we'll take a little bit closer look at this case, the Huerta case, for compensable time, and this is working under wage order number 16, which is a construction, drilling, logging, mining. That's what this case was looked into in the courts. However, we see it kind of looking at like it's the same as in all wage orders. But in Huerta, the employer had a security checkpoint to enter and exit the work site. They had to pass through the security checkpoint. And the security guards would scan the employee's badge and sometimes actually do like a little check of their vehicle. So peer into the vehicle, spend some time, maybe 30 seconds to a minute, maybe longer, maybe they start chatting. And so a line would form. And that would take the employees about 10 to 30 minutes to pass through the security check. Well, this time was off the clock. Employers not paying for this time. So Huerta brought this case up. And the California Supreme Court found that this time was compensable as hours worked because the employer required specific supervised tasks. And that's the key here. There were specific supervised tasks during the checkpoint. They had to present their badge. They had to maybe be subject to a vehicle inspection. And so because that time was controlled by the employer, it was deemed as on the clock, and the employee should be paid for that. So some tips here, failing to properly compensate employees for these activities can result in such wage and hour penalties. So do not permit pre and post shift work if you're able to control that. You need to make sure that the employees know that they're not engaging in pre and post shift work. So things such as security screens are happening on the clock, not off the clock. Gearing up machines, logging into computers, donning and doffing protective gear if they're trying, putting uniform protective gear on to do the work. That takes time. Answering emails or discussing work tasks for the day. If we start talking and chatting as I'm exiting the door and we get to talking about the meeting we have tomorrow and we really need to button that up and we start going and suddenly 10-15 minutes goes by and I'm off the clock, I need to adjust my time card. We need to especially train our supervisors in this area because that's when it happens. The supervisors get to wait before you go and we start chatting or we're sending that email out and we need a response before the end of the day. And so now I've asked you to do work and there's proof of that. There's evidence of that. So locking up, setting an alarm, that was like that Starbucks case where the employee had to go, there was a supervisor and he would go and set the alarm after he had clocked out, but that might have taken some time and maybe somebody forgot something. And so he had to undo the alarm, let the employee back in to get whatever they forgot. And then he set the alarm again. Well, all that takes time. And it was increments of time, yes, but they add up. And so now these cases are becoming more clear that employers need to pay for this time. So you may be risking a wage at hour penalty if we're not paying them appropriately. Yes, Juliana.
Yeah, so we got a great question in the Q&A and I thought let's answer it live. So someone asked, how does the de minimis doctrine kind of play into this? And we have different rules in California. We don't follow the federal rule on that. So Astrid, would you like to discuss it? I can also jump in here.
Jump in. Yeah, no, the de minimis.
So that Troaster versus Starbucks case that Astrid mentioned really addressed this head on, where they said in California, we don't follow the federal de minimis rule the way the federal law does, where we would let a few minutes or seconds go by where we don't have to compensate for that. In California, and they didn't give a bright line rule on exactly how many minutes, does it cross that threshold that we need to be accounting for, but they basically said we have the technology now to be tracking time down to the minutes, and so there shouldn't be situations where you're allowing a few minutes of time to go by and not be included on that time card. And where employers really get stung on this is they might not, let's say, track that time. And now you have a bunch of other penalties that follow from that. Maybe that would have pushed the person into daily overtime if they worked more than 8 hours in that workday. You might have a wage statement penalty now. So this is not an area where you want to kind of play fast and loose with it. We would recommend catch up with the technology to make sure you're tracking time down to those few minutes at the end of the day or beginning of the day and correct those time cards.
Yeah, Juliana, before you go, we actually had a question in the chat, which is great too, because we were just discussing this before the webinar. So this employer gives his store managers an extra 2 hours a pay period of manager pay because they answer text messages and emails from the team off the clock. And so she tells them to let her know if it ever goes over 2 hours, and then she'll pay accordingly. Is this appropriate?
That's a good question. We have heard some companies doing that. I would be a little bit careful in how that's set up. You wouldn't want a situation where it's viewed as a non-discretionary bonus that would impact the regular rate of pay. And so then you might not actually be compensating overtime at the correct rate of pay because you would have to factor that in if it is viewed like a bonus. So I would proceed with caution with that. Maybe reach out on the hotline, or you could get some legal counsel if needed, because we would tend to recommend that you want to go based off of exact time in most situations. Do you have any other thoughts on that, Astrid?
No, I would agree. When you brought up that bonus thing, it made me nervous too, that it could be that. And so maybe just adjust that time card accordingly would be the best thing to do. Another
Sometimes
question.
no good deed goes unpunished in California.
Yeah, I agree.
Yeah, and if they're exempt, obviously you don't have these same
Right.
issues. You can
Yeah.
add those bonuses on just fine.
So another question came in, which is great for everybody. So the employee has to clock in by web. So they have to actually turn on the computer, let
Mm.
it, warm up and get going and log in and then log into the HRIS system to clock in. And so depending on how much time that takes, that could be maybe viewed as compensable time, that those small increments of time that add up as well. What do you think, Juliana?
Yes, I agree. So you might want to see if there's other options to track that time, or if the computer already be set up and ready to go by an exempt employee that's there, so that that person could just start tracking their time. I think if it's just a few seconds, it might be fine. If it's
Sure.
starting to take a minute or a couple minutes, which it can, you might be getting into some hot water there.
I think communication is key and just ensuring, hey, if there's a problem, putting it in, let us know. Like, for example, this
Mhm.
morning getting into this webinar, it took me a while to restart my computer and get it going. It took some time. And so there might be moments where maybe something crashes and you're unable to start sooner than you do, so that you adjust accordingly at those cases. So communicating and telling your employees, hey, we pay for every time we're in control, we're
Mhm.
happy to look at things that may go haywire, and we will compensate you for that. So that keeping that line of communication open.
Yes, and I would include that in that kind of language in your policy as well. Let us know if there
Hmm.
is something that's missing from your time card. Looks like we have another great question here, Astrid. So recommendations on tracking time when taking phone calls outside of regular work hours. What are your thoughts on that?
Yeah, it could be as simple as an email to the employer where I worked this much time, or having that old school, timesheet where you're logging it in, or
Mm.
having a web-based app that tracks the time, but then ensuring that you're paying for that cell phone, at least a portion of that expense reimbursement, if we are requiring the employee to track their time with a phone. There's so many apps now that does it, and it's very easy to do, but we just have to remember to compensate employees when we're requiring them to use their phone for that.
And yeah, and in CEA's policies will include a statement that employees need to get authorization from their supervisor to work outside of their regular hours. Now, if you were to find out about that, even if it was unauthorized, you would still have to pay for it. But it's good to remind them, if that is your setup, that there's a couple steps that need to be taken. They shouldn't just be working outside of their regular hours and accessing their work stuff on their cell phones.
Great. Thank you. Good job, everyone. Great questions. Thank you, Juliana. So remember, as in summary, just requiring them to perform any tasks, and that employer control is what we're looking at. And these courts have very much clarified that we need to be compensating employees for this, or you're risking that wage and hour penalty. Employees, like you said, Juliana, no good deed goes unpunished. Employees may say, I'm fine with it, and you're okay with it, and hey, we come to this agreement, but Juliana and I have seen it. You probably have seen it too, employers where you think it's okay now, but then they get upset, something happens, they need money, future down the road, it becomes an issue and a concern, and the employer is the one that typically loses these cases in California. So let's be careful with that. There were a few other issues that came up with the Huerta case. And it was more of a win for employers in this time. So after this must have been a major, huge area work site where Huerta had to go, because after that, waiting 10, 15 minutes for that security check, employees had to drive another 15 minutes before reaching the employee parking lot. So they were required to comply with certain rules, such as the speed limit. They had to follow policies. So the courts looked at that, like, do we actually have control when the employee is driving 15 minutes to get to the parking lot? How much controls does the employer have? Huerta argued, look, I have to follow the speed limit, I can't go too fast, other laws that may apply, other policies that may apply while I'm doing that driving. But the court found that wasn't sufficient control, and that drive time was not compensable. So that's good. We don't have to pay for that drive time that it takes. Security check, yes. The drive time, the extra drive time, no. So that was also looked at, and that's a win for employers in the Huerta case. The other thing that came up in this case was on-duty meal breaks. So there was a union, and based on that CBA that was there between the employer and the union, employees had to remain on the premises for meal periods, but they were not paid. And so employer says, well, the CBA said we don't have to pay them. But the court found that the employees have to be paid for on-duty meal periods. Again, that control, we're not allowing them to leave the facility. So even if it's under a CBA, which is very interesting because typically we just kind of employers are like, well, they agreed, employer and union agreed to this. But if it's a violation of law, if there is something that is takes precedent over the CBA. So we want to make sure that we look at those CBA agreements. And if I think I had one once where the CBA said they didn't get sick time, well, that's inappropriate. You can't have that. And that was unusual to us. And we referred that employer to counsel because you can't have things like that. So court found employees must be paid for on-duty meal periods, even under that CBA as well. So some pro tips here. So on-duty meal periods are rarely permitted. We want to remind employers about that. It's only when the nature of the work prevents employees from taking a meal break and the employee has to voluntarily agree in writing that they are okay with staying on the premises. So there has to be some sort of an agreement, a written agreement, and then allow your employees. So typically we would allow employees to leave the premises for both meal and rest breaks. And if a meal or rest break is insufficient, then premium pay is owed. Just want to remind you of that too, that premium pay is paid at the regular rate of pay. And you also have to have a separate line item in your wage statement that actually specifies that this was premium pay. We're not just paying an extra hour of compensation. We're actually paying a premium pay specifically for this missed meal period, or it was either insufficient or it was taken late. We didn't give it to them that day. We didn't allow them to leave the premises, that kind of thing. That where premium pay is. You don't owe premium pay if you actually have an agreement with the employee for an on-duty meal period and you're paying them for that on-duty meal period. So remember, premium pay is in addition to the time spent working during the meal period. So you're paying them through the meal period and then you're paying them that. Anything you want to add to that, Juliana, or any other clarity?
No, I think you did a great job on that, Astrid. And it's also important to check if they are working through the meal period. If you have a standard 8-hour day, they might now be going into overtime in California as well. So that can be another issue that gets tacked on. And just like your example, where at the end of the day, that supervisor's checking in about work tasks, if that happens during the meal break, that can also be an issue where it was interrupted now. And so you're going to be owing that penalty pay.
Great, thank you so much. And then I see Pearl is on right now. Did you have a question?
I'm sorry. I don't have a question. My
Oh.
apologies for being tardy. I just received the link.
Okay, no problem. Thank you. Okay, so moving on with our next area. We have good news and bad news here when it comes to health and safety updates. The good news is we don't have a COVID slide, which is amazing because I think we haven't been able to say that we don't have a COVID slide in like 4 years now. So this feels a little bit more normal and optimistic for 2024. But I think the powers that be said, well, we don't have COVID, but let's put something else, a new program in place. And that's this workplace violence and heat illness. So maybe the person who was doing COVID and taking care of that can now be in charge of this new health and safety update, which is the Workplace Violence Prevention Plan, which is a big undertaking. So we're going to talk about that next. A little bit a history behind the Workplace Violence Prevention Plan. In 1993, California became the first state to require healthcare facilities to develop and maintain a violence prevention program. So this has been in place for over 30 years already with the healthcare industry. And for 30 years, Cal OSHA has been contemplating doing this for all industries. But instead, they never got around to it. They couldn't really do it. They didn't know how. Well, the legislator stepped in. So many things happened, and this is out of the Bay Area, actually. There was some legislation that came through, and so Senate Bill 553 was enacted at the beginning of this year. And so Cal OSHA is the enforcement agency behind this. Legislation passed through Senate Bill 553, but Cal OSHA will be the enforcement agency and responsible for this. So Cal OSHA still has some time to revise the regulations until the end of 2026, in fact, but so there may be some changes possibly to this new program. However, for the most part right now, since they have till the end of 2026, we're pretty confident it's going to stay very fairly similar to how it is right now. And so the requirement is that we establish, implement, and maintain a written workplace violence prevention plan by July 1st. So here we are, we're sitting June 12th. You still have a couple weeks, which should be enough time for you to complete this, so you're okay. If you've never heard of this, this is great. I'm glad you're here because you do need to have this in plan in place by July 1st. It's going to include employee engagement and annual training requirements, and we'll kind of go through step by step on what that's going to require. And then Cal OSHA does have some resources for employers to follow. There are some things, as well as CEA, we have some other additional items above and beyond what Cal OSHA provides to support employers out there. Let's talk about some exceptions that Senate Bill 553 has. The exceptions are some teleworking employees. So if you are a 100% remote teleworking employer, you are okay. You are exempt from this law, but this has to be 100% teleworking at all times. That means no annual meeting where an employee comes in, no biannual meeting, not on occasion I come into the office. This has to be 100% remote. So most employers are probably not going to be able to be exempt from this. Also, places with fewer than 10 employees at any given time. And again, that keyword at any given time. So if you have 12 at any given time, you will not fall under this. So it's 10 employees at any given time. Plus, if you do have 10, you have to also have to not be accessible to the public. So if you see the public at all and only have 5 employees, for example, a coffee shop with only 5 employees, you have access to the public, and so therefore you are not exempt from this. But if you do happen to have less than 10, you never see the public, and you have an IIPP, which is an injury illness prevention plan, you will be exempt. So again, very few employers that will fall into this exemption. Healthcare facilities, like I said, they've had their standard for about 30 years already. Department of Correction and Rehab and law enforcement also have their own plan. They've had to deal with a lot of unique situations when it comes to violence in the workplace, and so they've had their own plan as well. So let's get into the weeds a little bit more, get into the details here. What are some examples of workplace violence? So they actually specify under the Senate bill, it would be a physical attack with or without a weapon, which could look like employees fighting in the workplace. This could fall under that. Or maybe a client attacks your employee. This would be a physical attack with or without a weapon. It could be a threat of physical force or use of weapon. So just a threat, I'm going to kill you, I'm going to do the harm to you, as employees do in the workplace. That can be treated as an incident that will need to be logged, and we'll talk about the log in a second. A sexual assault or unwanted verbal or physical sexual conduct. So you're going to consider your sexual harassment claims in here. So not only do you have to, under FEHA, do a sexual harassment investigation and claim, but it may also fall under your violent incident program here where you need to log it. An animal attack, so if you have employees who work off-site who are traveling and maybe get bit by a dog. We had someone say, what about a bee sting? So things like that could fall under an animal attack. And there's an other, and the other hopefully will get clarified by Cal OSHA once they get their regulations and get some more information on this. That will also likely fall under that. Juliana, do you want to step in and give me any other examples possibly of what you've seen that has also maybe fall under this? And
I just wanted to expand on how broad this law is. So it could cover someone even just making a joke if it resulted in psychological trauma or stress to the employee that received it. So in Astrid's example, I could just kill her. If someone took that seriously and had stress as a result of that, even if it was intended as a joke, that would constitute workplace violence. So that's a really important point to remind your employees, train your employees and supervisors on that. And that, even a verbal derogatory comment you might not think would be workplace violence, but injury is not required for it to be considered workplace violence. And there's 4 buckets or types of workplace violence. So type 1 is when it's committed by a stranger entering the workplace to commit a crime. Type 2 is when it's by a customer, patient, client. Type 3 is employee on employee. It could be a former employee as well. And then type 4 is when it's somebody that has a personal relationship with the employee. So that's when domestic violence or intimate partner violence kind of spills into the workplace. So very, very broad. It can come in all kinds of forms. And our plans need to be directed at mitigating those different hazards.
Thank you, Juliana. I appreciate that. Let's talk about So we do need to we got to get educated ourselves on this topic, because we need to know how to treat it. And like Juliana said, how to train your supervisors, your management team, and all your employees on this. So here's a question. Does the employee training need to be a certain duration, like harassment prevention, and required to cover specific topics? So the answer to this is no specific duration requirement. So it's not like the 1 hour, 2 hour with harassment. There is no specific duration, but the trainer does have to be knowledgeable in the plan. So the trainer has to be someone who probably worked on the plan, who surveyed employees, who participated, who knows about their plan. And it does need to be interactive. So we can't just have a recording and let it go. If you do a recording, someone still has to be there live to answer questions. So it does need to be interactive, and it must cover specific definitions, as well as like the ones we mentioned, the ones that Juliana mentioned, the types of violence, the type of people who can conduct it. Those need to be introduced to your staff and talked about, as well as any topics customized to the business. So this is not a one size fits all. You actually have to go and participate, and again, you have to allow employees to request a copy of the plan. Where can they find it? You have to allow participation into the plan. Who wants to join our committee? Who wants to join this program where they can also participate? How and where to report the concerns and seek assistance, and strategies to avoid harm. So those are the things that are going to be discussed in your training. The hazard specifics to the job. So you're going to do a hazard inspection, and you're going to look into what are these specific hazards that can possibly happen in our work site, have a discussion on that. And then the corrective measures implemented by the employer. What are we doing to try to solve or mitigate these hazards? And then the information on the violent incident log, you need to make that available. Where can they request a copy? Where are we going to have this? Very similar to that workers' comp OSHA log that you have to keep. Very similar to that. You're going to log all those things into the violent incident log and make that available for your employees. Multiple languages, we've had some questions where do we have to do this in English and Spanish if we have bilingual in another language? It's recommended to have an interpreter or someone who knows the training and be able to deliver the training in the language that is known to the employees, because that is a requirement. Employees need to be able to understand the plan. The plan itself doesn't have to be translated, as far as I know, Juliana, but you do need to make the training available and discuss this training and the definitions and all that in the language that's understood by your staff. So please be mindful of that. Did I get that one right with the
Yeah,
language?
you're exactly right. We had a question come through on the chat, and I think this is one a lot of employers have. So our payroll company says we meet the interactive requirement if we set up a way for employees to ask questions throughout the online training. Is that true? So that's going to depend. I would have hesitation with that. With online on-demand trainings, they're probably not compliant, because it needs to be that the trainer is someone knowledgeable in the employer-specific plan and can answer employees' questions. So be really careful with any sort of online, on-demand type of trainings. If you're doing it over Zoom virtually, that's fine. And you can use those online trainings to supplement, but they just won't be fully compliant.
Yeah, it can't be where your payroll company is the one doing the training. They probably were not part of the plan and in implementing it and doing the hazard inspection and requesting the feedback from your staff. So it has to be someone who has the knowledge of the plan that is available to answer those questions.
Right. So maybe if they've reviewed it extensively, but just be careful with that.
Yeah. Okay. Good question. Great. Thank you. So what are the actual ongoing requirements for the plan itself? You do have to and get your calendars out, have someone who's organized, ensuring that we're complying with this, because you have to have an annual review of your workplace violence prevention plan, an annual soliciting of employee feedback. So we're doing that now to implement. So you can't even do your plan until you solicit the employee feedback, because that needs to be a part of the plan that you create. There has to be an annual employee training. So you're doing that by July 1st and then annually from here on out. And then you're doing periodic hazard inspections. And that periodic could look like biannually, every quarter, every month that we're doing a hazard inspection. That going to look differently for you. You all have to decide what that periodic hazard inspection looks like. You do need to have one if there's an incident. So anytime there's an incident, there's a report of harassment that's looked upon, there is a fight that breaks out, so there is an actual incident that occurs, then you need to do that hazard inspection and retrain your folks on how you're going to prevent this from happening in the future or try to minimize the potential of that happening. So these periodic safety meetings, again, you're going to look at what does that look like. Are we doing the monthly, quarterly, biannually? But at the very minimum, it needs to be annually, and then anytime there's an incident as well. So CEA has a comprehensive, very comprehensive DIY package. Cal OSHA has the template, the written plan already. We include that in that DIY package, but the DIY package has so much more. If you're a CEA member, you have free access to the package. You may have already gotten started on it. If you're not a member, you can still purchase this DIY package as well. And we do have a webinar coming up next week if you'd like a little bit more detail on the kind of play-by-play of the plan so that you're familiar and know how to do this. I highly recommend that. You can go over to our training page as well for that. But that DIY package is going to include the hazard inspection. It's going to have some questions for your staff of what to ask them. It's going to have checklists for you. So a lot of those forms and templates are already done for you. And then hopefully by the end of the week into the store, we're also going to have a PowerPoint template for your training. So it will be a DIY also, a kind of train the trainer template. So if you don't want to even do you just want the PowerPoint already done, the PowerPoint will be somewhat done. You'll have to go in and customize and put in your information. It'll tell you there where to put in the information, but the template will help you with your trainings too. So look out for that. In fact, if you are interested in that, you can put your email into the chat. I'm sure Anna will track your email so that we can get you that link once that PowerPoint is up on our store. So that's a lot for workplace violence prevention. And again, you have 2 weeks. That should be enough time to get this done. Schedule that information now. I think the most important thing is to survey your employees and get that hazard inspection, all those things done so that you can get your training done before that July 1st deadline. All right, so the last thing I'll talk about before handing it over to Juliana is the indoor illness heat plan that's set to come out here soon. So on March 21st, Cal OSHA voted to adopt an indoor heat illness standard that would apply to most indoor work areas when the temperature reaches or exceeds 82 degrees. So, but at the last minute, the California Department of Finance withdrew their required approval. They needed it, and they withdrew it. So now the standard's on hold. Cal OSHA is set to vote on this again, and so we do think it's going to probably take effect. It's just on hold right now, but it can be as of even as early as July, it taking effect. So really stay tuned. We will have a blog about this. We will send an alert to our members regarding this once it passes, because it will likely pass. Remember, we already have an outdoor heat illness prevention plan out there for employments that are required to follow. It includes things like the shade, cool water, cool down breaks, all that's already set. CEA members have access to this toolkit on our website already. And in the current form, the general requirement will be, if it stays the way it is, to have that written plan, provide training for your employees, and have those cool down areas in addition to some more requirements. So be on the lookout for that.
All right, so I will go ahead and take over here for the second half, and Astrid will be monitoring that Q&A box. So yeah, so with safety, there are a lot of plans that we are looking at right now that we're required to have. So just kind of as a reminder, we have our injury and illness prevention plans. We have our workplace violence prevention plan by July 1, outdoor heat illness, indoor heat illness is likely coming, and then our COVID prevention plan. So that's a lot of plans that we have to have in place. And it seems that we're just continuing to add to those, so we can help you out if you have questions about that. We also have safety partners that we can refer you to if you do need to get your IIPP done, for example. All right, so now we are going to turn to some new employee rights and protections. And as Astrid mentioned, this year is a little bit unique because we actually have a number of federal updates. The Equal Employment Opportunity Commission, they're a federal enforcement agency. They have been very busy with some new regulations and new cases that they're getting involved in. So this is a little bit different, where we're actually going above and beyond, in some cases, what California already requires, which can be a little bit surprising. So all employers should pay attention in and out of the state of California to some of these updates that we are going to cover. So the first one that I'm going to go over is the Pregnant Workers Fairness Act, or PWFA. This is a federal law that passed last year in June 2023. You might have heard about this, heard some inklings of it, but maybe didn't pay too much attention as a California employer. But there is some important information that we need to pay attention to in the EEOC's regulations. So they just adopted a regulation interpreting the Pregnant Workers Fairness Act and going over how they're going to enforce it. And that regulation is going to become effective in just a few days on June 18th, 2024. Now, this law was modeled after the Federal American with Disabilities Act, and it applies to employers that have 15 or more employees. So if that's your head count, if you have 15 or more, whether you're inside of California or outside, you want to pay attention to this. Now, you might be wondering, well, if we already have the ADA that protects employees when they are disabled or experiencing a disability, why do we need this PWFA? And it's actually more expansive than the ADA because it requires accommodations not only for disabilities, but also for limitations, so lesser issues related to pregnancy, childbirth, or related medical conditions. So that can be things like the employee experiencing occasional morning sickness. They might not have a disability or rise to that level, but they are experiencing occasional morning sickness and maybe need to come into work late or spend some time at home on a leave. Sometimes it can be very intense. Migraines, or the need to attend certain prenatal appointments. So for those of us that had children, you may know that there are a number of prenatal appointments that need to be attended. And so that's really what this law is aimed at, is protecting those types of situations, even if it doesn't rise to the level of a disability. It also protects things beyond just strictly pregnancy. So the employee's reproductive choices, uses of contraception, if they're dealing with infertility issues, menstruation issues, stillbirths, miscarriages, all of those things would be wrapped up in this law, would be protected. So for example, an employee could not be harassed based on those statuses or going through those issues or retaliated against for needing to take some time and needing an accommodation related to those issues. So it is more expansive than what the ADA has already provided. So in California, we know we already have extensive protections when it comes to pregnancy rights and pregnancy disability leave. So I wanted to cover that because largely we already have these protections in place in California. So I want to review that for us. So remember, for California law already requires employers with just 5 or more employees to do the following. We need to reasonably accommodate employees who are disabled or affected by pregnancy as certified by their healthcare provider. So that affected language is very similar to the limitation language that's used in the PWFA. So it would protect those things like prenatal appointments or someone experiencing morning sickness, or if someone has a lifting restriction based on their pregnancy as advised by their doctor, or they say, you know, I can't be around this certain substance, I need to be quarantined from that in a different work area. Those would be things we would potentially need to reasonably accommodate. We also are unique in California that we have pregnancy disability leave. So we provide up to 4 months, or the equivalent of 17.3 weeks of pregnancy disability leave as certified by the healthcare provider. So it's not an automatic 4 months, but the healthcare provider will determine when that employee is disabled or affected by pregnancy. So how this can sometimes play out, it can be intermittent, so it doesn't have to be all at once, but you might have someone that, let's say, is experiencing that morning sickness or intense symptoms maybe in the beginning of the pregnancy, and they might need to take some time off for that. And then they might be fine as things are moving along, and then they get closer to the end and there's additional issues that come up. And so then they may need to take some more time. So in a typical pregnancy, what it can look like, but again, it's always going to come down to what the healthcare provider says. It's typically going to be 4 weeks before the due date and then up to 6 weeks after for a typical birth, 8 weeks for cesarean, that they're going to be considered disabled. So that's almost kind of automatic, but it can go beyond that up to the 4 months. And as a reminder, in California, there's really no eligibility requirement. So it could be their day one on the job, and we have to make sure that we're accommodating them and we're providing that pregnancy disability leave if that's certified by their healthcare provider. In California, when they're returning from pregnancy disability leave, they would also need to be reinstated to their position or a virtually identical position when they come back. So we have to hold their job for them. They get continuation of their healthcare benefits with you if they have that with you. And you can't force them to use their vacation time during that pregnancy disability leave. So we have extensive protections in California beyond what the PWFA provides for. And of course, we cannot harass, discriminate, or retaliate against pregnant employees. I think we all know that. So your question might be, does the PWFA even impact California employers? And the answer is actually yes. So there are a few instances where that EEOC regulation is more protective. So if you are an employer with 15 or more employees, you would want to pay attention to that. If you're smaller, then you wouldn't be covered by the PWFA. So you can kind of tune this part out. But here's what's new. I think this is the biggest change that we see, is that there's actually a requirement to temporarily suspend essential job functions. So that's never been the case before. Under the ADA or the California version, the FEHA, you are only required to accommodate someone that is able to perform the essential functions of their position. They have to be qualified, and that's one of the requirements. Whereas this is saying, even if they can't perform those core functions, you may still have to accommodate them. And we're going to jump into an example of what that might look like. The EEOC also says we have to provide certain predictable assessments. I like to call them automatic accommodations because they say there really should be very limited interactive process. Just pretty much someone making a request, a pregnant employee making a request for one of these things, they're going to assume in virtually all cases it would not result in an undue hardship. So that's going to be things like carrying water around, additional or longer breaks for eating or using the restroom, sitting when standing is required of their job, and standing when sitting is required of their job. So they might say, you know, I need some sort of standing desk because I need to get up. I can't be in the same seated position, or maybe I need a chair. And we would need to accommodate that. So I think probably a lot of employers are already doing these things. They're acting in good faith. One issue here is that the EEOC really doesn't put any sort of parameters on this. So if there's a concern that someone's abusing this, let's say they're going to the restroom every 10 minutes and they're claiming it's related to the pregnancy, the EEOC really doesn't have any guidance on how an employer should handle that situation. So that might be an area, while this is still kind of gray and we don't have a ton of answers or case law, that you might want to consult legal counsel if you have those concerns. But I do think that that's going to come up very rarely. And then not requesting medical certification in certain instances, such as with these predictable assessments. And that also largely already tracks in California what our requirements are. So if someone needs a lactation accommodation, for example, to pump at work, we wouldn't be requesting that medical certification from them, or if it's something obvious. So you already know that somebody's pregnant, it's been certified by their doctor, and the EEOC example that they provide is that somebody needs a larger uniform to accommodate them. We're not going to ask them for a medical certification for that. We already know they're pregnant. It's an obvious need that they are going to need that accommodation. Yeah, Astrid, do we have a question?
Yeah, so there's a good one on here in the chat. Can we request, you're kind of answering it right now, so I thought I'd ask it. Can we request something from the healthcare provider for a limitation, example, morning sickness, or do we just take their word for it? So when it's a very general and broad note they bring us, can we ask for more specifics?
Yes, so we can ask for more specific on what the limitations are. So with some of those examples is, you know, I may need some time outside of work because I'm experiencing this morning sickness, or I can't be around this certain substance. So we can have a medical provider certify that for us. Where we wouldn't want to do that is for these predictable assessments that we have here, that basically for everyone, the EEOC is saying you should grant these requests. So carrying water, additional breaks, and sitting or standing. Great question. All right, so let's jump into some Q&A here. Our employee Erica is pregnant. she presented a doctor's note certifying that she can no longer lift for the remainder of her pregnancy. And for Erica, lifting is an essential function of her job. So let's assume that Erica's job is really revolves around taking boxes from the warehouse and loading them onto the truck. How do we respond in this situation? So according to the EEOC, if a pregnant employee is temporarily unable to perform one or even more than one essential job functions, you may need to offer light duty, change in work assignments. So maybe we're going to assign Erica some office work or filing work, potentially for up to 40 weeks, unless, which is the typical duration of a pregnancy, unless the employer can demonstrate that it would cause an undue hardship. And undue hardship is a very specific legal standard, and it's typically difficult to satisfy. So how this is a little bit different, if this was an essential job function prior to the PWFA, you might say, well, we're going to offer you a leave of absence since you can't perform the essential functions of your job that may be required by the ADA, FEHA, or start that pregnancy disability leave. Whereas now you would maybe have to consider offering those other duties or changing work assignments. There's still gray area on how that would really play out. So we're hoping to get additional guidance, but this is where the law stands. Again, it's probably pretty rare that it's going to come up, but I would recommend that you let your supervisors and managers know just about some of these things, especially the predictable assessments that they know these really need to be automatically granted. All right, and I also want to make a note on lactation accommodations. So this is another area where federal law has kind of caught up to California with the Pump Act in 2022, but California already has extensive protections regarding lactation accommodations. So under our labor code section 1030, you have to provide a reasonable amount of break time to accommodate someone to pump at work, and that can run with the paid rest breaks. If they need additional time beyond that, then it would turn into an unpaid break at that point. And you would also need to make sure that you are providing a private location, shielded from view, needs to be sanitary, of course, and that they have access to a sink with running water, a plug for the pump, and close access to a fridge where they can store that milk. So that might be a little challenging in certain employment settings. So it's something you're going to want to give some thought to if you do have a pregnant employee, and this might be a need for them. But in most office settings, typically an office can be used pretty easily as long as there's a fridge and a sink nearby. But just give some thought to that because it is something that we do need to accommodate in California. And if we don't provide those breaks, it's the same thing with the meal and rest breaks where we would owe that premium pay, that penalty pay. Yes, Astrid.
And you may have covered this, excuse me. Is there a time limit that we can set on those lactation breaks?
Not as far as what's addressed in the labor code. So it kind of runs into those tricky situations where if you think that it's happening, more than it should, that might be an area where you'd want to consult legal counsel. Hopefully that's not the case, and you can kind of work with the employee and have a discussion about, well, let's come up with a plan. What do you think would work for you, and let's try to can we line it up with the rest break? So I think, having a simple conversation can sometimes help address that than just not putting any sort of thought into coordinating that.
Definitely. Yeah, being reasonable. What about, can you provide the examples for the temporarily suspend of essential job functions? This is a little bit back
to the prior question.
Yeah.
Yeah, so essential job functions are basically core to the person's position. It's really the reason for the job position. So this is saying, but prior to this, we wouldn't have had to accommodate that in the workplace. We would offer a leave of absence if someone wasn't able to perform the essential functions. This is saying you actually would have to keep the person on the job for potentially up to 40 weeks if they're able to, and allow them to do other work. So where it's unclear is, well, do we need to keep their same number of hours, their same pay? Those are questions that were left open by the EEOC. So we're hoping that we'll get some additional guidance on that. Again, I don't think this is going to come up all of the time for employers. So it's good to know that you have that in your head, that if this comes up, we may potentially run into an issue. And that might be an area where you reach out and get some additional guidance from counsel. And then the last issue that I want to cover on this is that the EEOC regulation on PWFA takes our lactation accommodations one step further. So this is also just good to know. It says that It goes beyond just allowing someone to pump at work and could actually include permitting the employee to nurse the child during work hours where the child is in close proximity to the employee. And the examples that they provide is for remote workers or somebody that takes a break to visit a nearby daycare facility, that could be part of those lactation breaks. So be aware of that, because that is something that takes an additional step beyond what California has already provided for. All right, so let's continue moving along with our employee rights and protections. We're going to go over some refreshers and reminders, starting with paid sick leave. We've still been getting a lot of questions from employers on the paid sick leave change that happened on January 1, 2024. So under SB 616, paid sick leave was increased. The annual amount of paid sick leave from the 3 days or 24 hours that we've been used to now 5 days or 40 hours per year. And I want to stress that that was really only the main change, is that we are going from higher usage and accrual caps now on paid sick leave, but all of our other paid sick leave laws and protections have largely remained the same. So what that means is you can still use a lump sum or a front loading approach where you grant all of that sick leave up front. A lot of employers do it on January 1st, for example, or they might do it based on the employee's anniversary date, and it's use it or lose it, and then it resets on the same date every year. So that's still totally okay. Also okay to use the accrual method, and the same rate that they earn is still in effect. So the accrual rate is still at least 1 hour for every 30 hours of work that they perform for you. They get that 1 hour of paid sick leave, and that includes their overtime hours. That goes towards that. Now, the accrual method, if you do accrual, the cap on sick leave is increased from the 48 hours or 6 days to now 80 hours or 10 days. So you're going to want to make sure that you've updated this language in your policy and your employee handbook, and that also your payroll system has accounted for this. One of the things that we have to have on the wage statement or in a separate writing at payday is the amount of available paid sick leave for employees to use. And sometimes for those that use the accrual method, it can be a little confusing because the accrual cap can be larger than the usage cap that we've placed on it. Employers can limit usage per year to the 40 hours. So one really simple way that you can do it, how we do it in our payroll system, is we'll say accrued paid sick leave, and then it might be, 80 hours available to use 40 hours. And that keeps it really clear for everyone, including supervisors. So they see, well, what actually is available for the employee to use? And then anything that they're not able to use or haven't used in an accrual method would roll over to the following year. It keeps rolling over up to that 80-hour cap. It's not a use it or lose it. So you can do either approach is fine. And if you have additional questions, we encourage you to reach out to us, give us a call. We'll be happy to answer those for you, because it can be a little bit tricky. The accrual method is a little more complicated to administer than the front load or lump sum approach. So some pro tips when it comes to paid sick leave: you want to ensure that your wage statements or another writing furnished at payday, as I mentioned, needs to reflect that available paid sick leave for use. That's one of the requirements. It could lead to a penalty if you don't have that. So do an audit, check your wage statements, make sure that this is reflected, reach out to your payroll provider and make sure that you get that squared away, and including with the updated amounts. You want to train managers on the extensive sick leave protections. I can't tell you how many managers and supervisors have a lot of questions with this, or maybe don't have a great handle on it, where someone's having a lot of attendance issues and maybe there's some protected sick leave time in there, but also other issues, and they kind of lump everything together and maybe discipline the employee for mandatory sick leave use or count it against their attendance, which would not be permitted. That mandatory paid sick leave use is very, very protected. So we do want to educate and train our managers on this. So they don't need to know all the ins and outs like HR professionals need to know, but it's good for them to have at least a basic level understanding that we don't count that mandatory paid sick leave time against the employee. And then if you have a PTO policy, that makes things even more nuanced. So make sure that with your PTO policies, you're satisfying all the sick leave requirements that we just talked about with that 80-hour cap, but also all of the vacation requirements. So the employees get the protections of both when you have a PTO policy. We typically don't recommend PTO policies for that reason. We recommend keeping your sick and vacation programs separate. But once you combine it all together, that means that all of it has to be paid out upon termination of employment. And we have to make sure we are meeting the vacation requirements, which is at least 1.5 times their annual rate. That's one cap that we would have to check in addition to the 80-hour cap. So again, those can get more complex. So give us a call. We can also help you out with crafting policies, working on customized employee handbooks, so that you have peace of mind that you've done it right and you're not going to walk into any sort of potential claims. All right, another area that I want to talk about is non-compete agreements, because there's been expansion in terms of protections or prohibitions against non-compete agreements, including at the federal level. Again, kind of the federal catching up to California. So just as a reminder, in California, there's pretty much an outright ban on non-compete agreements under our Business and Professions Code, and there has been for a very long time. So just simply stated, what is a non-compete agreement? It basically would tell the employee that when they leave the employment, if they do, that they're not allowed to go work for a competitor. And sometimes these agreements will say, you know, for X number of years, you can't go work for one of our competitors, or you can't compete with us within this geographic location. So other states would maybe honor that if they deem it's reasonable. In California, those are a no-no. They're considered against public policy. California wants employees to be able to freely move around and become employed easily. Now, SB 699 really just expanded these protections because there wasn't a lot of teeth to the law. A lot of employers would still try to wiggle in that non-compete language, or maybe even inadvertently not knowing that it was not lawful in California. And so now SB 699 creates a private right of action, meaning that the employee or applicant that was coerced or forced to sign that agreement can now sue the employer and collect damages for that. SB 699 also clarified that these protections apply regardless of where and when the contract was signed, and even if the employment was maintained outside of California. So kind of putting that into plain English, what that means is if you're a California-based employer, you should not be executing non-compete agreements with anyone, including out-of-state employees. Maybe you have people in Texas, Arizona, they should not be signing a non-compete agreement. SB 699 covers you entirely. If you're an out-of-state employer, you want to make sure you're not executing those non-compete agreements with any California-based employees. So very, very broad reach. And now we see that there's federal prohibitions on non-compete. So we might actually see this become a nationwide issue. So the Federal Trade Commission most recently and the National Labor Relations Board, those are both federal agencies, are basically saying that their position is that non-compete agreements are not legal in most cases. So this is actually something now that all out of state of California employers will want to pay attention to, take another look, maybe get some legal advice if you're an out-of-state employer. For California employers, I would audit your policies and handbooks and agreements and make sure that you don't have that non-compete language in there, especially if you haven't looked at things in a while. You might have some outdated policies. All right, so you might be wondering, well, what employment agreements are we permitted to utilize to protect our company? So some options may include agreements regarding confidentiality, trade secret, intellectual property, non-disclosure agreements. Those are all valid and lawful, and you would want to have a lawyer draft those up for you because there needs to be specific language in there. Most non-solicitation provisions are unenforceable. So that's a provision that would prevent an employee from hiring their coworkers, let's say if they go start their own competing business, or from trying to get your customers from you. An exception would be if they accessed confidential or trade secret information. They went and downloaded all of your customers on your confidential database. That would not be permitted, but it's a reminder as if you have that kind of data, it's probably a good idea to have a confidentiality agreement in place, an NDA in place, so that you're covering that as confidential information that they are not allowed to take from you. All right, so another area, once again, the EEOC is back, and another area that we have some expansion on is our harassment guidance. So after nearly 25 years, in April 2024, the EEOC updated its harassment guidance. They have 77 new examples or hypothetical scenarios of how harassment may play out in the workplace. I would recommend that all HR professionals and upper management take a look at this document. It's really helpful. It has nuanced examples. It's really not the basic, straightforward stuff that you might learn in kind of a regular harassment prevention training. It really is kind of next level. There's a lot of terminology that you probably haven't seen before from the EEOC. So I'm just going to go over some of the key highlights from this document. So again, this is not just California. This would be nationwide. So harassment can include intrusive questions about sexual orientation, gender identity, gender transition, or intimate body parts. So an example of that would be if someone is going through a gender transition and someone's peppering them with questions and asking private personal questions, and that is not welcome by the person. That is an example of harassment. They could actually bring a claim for that. Harassment of LGBTQ plus workers can include denial of access to bathrooms consistent with their gender identity, intentional and repeated misgendering, so intentionally using pronouns that are different from what they have asked. So again, we already have this in California. This has already been the case, but now we're seeing it expand on the federal level. Sexual harassment can be based on pregnancy, childbirth, or related medical conditions. So that's really just tracking that PWFA that we talked about. And then harassment can occur in remote work environments, which I'm sure many of us know. Harassment, of course, isn't just limited to sexual harassment. It can be based on any protected class. Someone could be targeted based on their age, race, gender, religion. We have almost 30 protected classes in California. And of course, it can occur remotely because it can be just verbal comments, right? Or those intrusive questions as examples. It doesn't have to be a physical act. So there's a lot of really great terminology included in this document, and it might be a good idea to kind of brief your managers and supervisors who have the requirement to report harassment that they know about, but they might not know, well, what are really all of the forms of harassment? So it's a good idea to refresh them on that. All right, and another emerging area for employers is artificial intelligence. Whether you like it or not, we kind of see a large spectrum with this. So some employers are really excited about AI. They want to use it in any way that they can. Other employers want nothing to do with it. They say, I don't like robots. I don't want to know anything about this. And then we have a lot of employers that are falling somewhere in the middle. But you do want to proceed with caution when using AI. And we're starting to see AI create potential liability. So in this Mobley versus Workday case, the EEOC argued that an AI company that provided resume screening services may be directly liable for discrimination. So what was alleged here is that this AI screening tool to save the recruiter hours and hours of going through resumes would actually filter out people based on disabilities or age, that they would tend to filter out those applicants more than other applicants. And remember, we always have to have a legitimate business reason or justification when those kind of things happen, where it disproportionately impacts a protected group. And so that's what's at issue here, is there really was no good justification for that. And so the employer could also be on the hook for that, for using that company and it involving this inadvertent discrimination. So we want to be careful with our uses of AI, and we would recommend probably that you still have a human involved as another filter. The Civil Rights Department at the California level also is currently working on proposed regulations to increase AI enforcement and limit an employer's uses on that. So we might have an update for you on that maybe by our annual labor law update at the beginning of the year. They might have their regulation by then, and we'll cover that for you. So this is a reminder to just proceed with caution when using AI. We do recommend that company leaders, whether you want to be involved with it or not at your company, should monitor those AI development. Consider forming an AI team or committee just to kind of be thoughtful around this. And then we would also recommend considering a policy and training for your staff on permitted AI uses or prohibitions at your company. Because if you say nothing at all, then employees are just going to make their own assumptions about what they may be allowed to use or not. You know, can I use an AI to write this article and publish this? You probably want to put some parameters around that. And for CEA members, on our HR forms page, we do have a sample AI policy available that you can download and tweak and include in your employee handbook. All right, this is another kind of fun one. So there's this proposed bill. So I want to be very clear, this has not passed, that would create this right to disconnect from work. So AB 2751 would basically require employers to define what their non-working hours are. So let's say they say our working hours are Monday through Friday, 8 to 5, and anything outside of that would be our non-working hours. And then the employer would be unable to contact employees during those non-working hours unless they want to schedule them, which means within 24 hours, or there's an emergency situation that justifies reaching out. And it would actually give employees the right to ignore communications during non-working hours and file complaints with the labor commissioner if they were reached out to on 3 occasions outside of working hours. So I'll be honest, when I first saw this bill, I had a moment of panic because I thought, wow, that is so broad. And just think about every aspect of employment that this could potentially impact. And so luckily, it doesn't look like in the current form that it's going to pass this year. It didn't get out of committee. So that's not to say that it won't pass eventually in some form or another. I would pay attention to this. I think we will probably see something like this. It was really modeled after European countries that are already doing this. But I do think that the legislature probably realized that they do need to put more parameters around this and be more specific when it comes to this. So stay tuned. Just as a reminder, for all of these kind of updates, you can follow CEA's blog at employers.org. And we're always just tracking these kinds of things and want to give you the information as soon as we have it. All right, so to summarize, what are our to-dos? We want to train managers on those predictable assessments that I mentioned for pregnancy and lactation accommodations, maybe give them a refresher. Consider for your reasonable accommodation policies or your request forms, do you need to update any of the language? So do you want to include, that we accommodate limitations or when employees are affected by pregnancy? Audit your employment agreements. Make sure you don't have that non-compete language out there. Proceed with caution when using those AI tools, and then keep your staff up to date on harassment prevention training. So CEA has a number of options for our members. We do have free online on-demand harassment prevention training available, so you can check that off. As a reminder, it's due every 2 years for your staff, and then upon hire, it's also due for your new employees. All right, and the last section that I want to cover now is industry and employer-specific changes. Astrid already mentioned some of these with fast food and healthcare. We're seeing this trend in California where we're having industry-specific minimum wage requirements. And I think we're kind of reading the tea leaves here with the legislature that this is probably going to continue, that they're going to start to kind of break off certain industries and subject them to their own requirements. So we might not have just one minimum wage that applies to all. We're going to have to start maybe going by industry. So the fast food minimum wage you may have heard about, it did go into effect on April 1, 2024, and it created this $20 an hour minimum wage for fast food workers working at chain restaurants. It also created this fast food council under the DIR, the Department of Industrial Relations, to recommend working conditions and set those minimum wages each year up until 2029. They have the authority to do that. I think this is perhaps the most interesting part of the bill because it basically allows them to fast track rules for this industry without having to go through the legislative process. So it still remains to be seen what they might do with that. So who does it apply to? Limited service restaurants, part of a chain with over 60 locations nationally. So that is not a restaurant where it's a traditional sit down with table service. We're talking about when they can take that food for immediate consumption. So some that come to mind, McDonald's, Starbucks, Dunkin' Donuts, Chipotle, those would all be examples of that. Luckily, the DIR did release some FAQs a few months ago that have provided a little more clarity around this law. So it does apply to franchisees and licensees. So even if you're not the owner of the brand, you might own just one McDonald's, it would apply. Food sold to be baked, cooked, or heated at home is not for immediate consumption. So if your business is a take and bake pizza, for example, that would not be for immediate consumption. And here they provided a really bright line rule, which I was very happy to see. If you're in kind of a mixed business and maybe you have some table service, but you also have fast food, what they're saying is it would apply to you if more than 50% of your gross income comes from selling food and beverage items for immediate consumption. And then the definition of fast food restaurant does not depend on the type of food or beverage. So you might not really even have food at all, or limited food. If you're a coffee shop like Dunkin' Donuts, I just mentioned, it would apply. And then the minimum exempt salary, they actually tie it to the fast food minimum wage. So as Astrid was mentioning, it's not the $66,560. They're actually saying it's $83,200 a year to meet the exempt salary level as a fast food chain employee. So that's pretty high. I think we're going to see a lot of reclassification down, or reclassifying people from exempt to non-exempt, so that they're not running into this salary, which is probably pretty high for a lot of localities. All right, and then also we have unique healthcare minimum wages. So there was this goal or this push under SB 525 for healthcare workers to earn $25 an hour eventually. And there are going to be some increases this year. Initially, they range. It's going to depend on the type of healthcare employer, but anywhere from $18 an hour to $23 an hour. And it was going to be by June 1, but they actually pushed this. There was a very last minute attempt to push this, delay it by 1 month to July 1, 2024. And then future increases thereafter are also now based on July 1. Now, to qualify as exempt, once again, we're going to see special rules here. So employees must be paid for exempt 1.5 times the healthcare minimum wage that applies to them, or 2 times the California's minimum wage, whichever is greater. So what that means is anytime California's minimum wage or their healthcare minimum wage goes up, they're going to have to assess which one's greater, and now what do we calculate for the exempt employee salary. And this is not only applicable to those we think of as traditional healthcare workers, so nurses and doctors, of course, but also really almost anyone at one of these covered establishments. So technicians, billers, janitors, security guards, at a hospital gift shop employees. So it's really, really expansive. And it does apply to almost every medical employer. So this is the schedule initially. We have large employers and integrated healthcare systems. They're at 23 an hour, hospitals at 18 an hour, clinics at 21 an hour, and all others at 21 an hour. And I know we get some questions from pharmacies and dentists. A lot of them would actually be exempt unless they do fall under one of those integrated healthcare systems. So if you are unsure of which qualification, we do have a bit.ly link there for you where you can access some more information on that. All right, so kind of now to wrap up, what do we want to be thinking about going forward mid-year? So we want to ensure that we are paying employees properly and capturing all hours worked. So we want to make sure for our exempt employees, we've classified them appropriately. In addition to the salaries test, they also have to meet a duties test. So make sure you've audited that, and then check out those local minimum wage requirements. If you have people working remotely or you're sending them to different client sites, we always want to check our local minimum wage requirements. Here's really the big one. Make sure you're in compliance with workplace violence prevention plan requirements by the July 1 deadline. If you are just starting this project, I would really recommend downloading OSHA's template and trying to take at least a first crack at filling it out as completely as possible. And then you'll know, well, what does this really all entail? What do I need to follow up on to make sure I get this complete? And also in conjunction with that, we'd recommend you get started on soliciting the employee feedback because you need that to make your plan compliant. And then consider policy and training updates regarding those pregnant worker accommodations, harassment prevention, AI issues, and stay tuned to our ongoing developments on CEA's blog at employers.org. And as Astrid mentioned, we do have a number of free resources that anybody can access, and I did put that link in the chat. And if you are interested in learning more about joining as a CEA member, you are welcome to reach out to us at any time. So it can be as low as $109 a month. And you'd get access to our extensive library of sample forms, including that workplace violence prevention toolkit that we were talking about. Or you could also join as a Premier Ultimate member if you do need that customized employee handbook, you want some consulting time with us, you'd like for us to help you out with an HR audit or maybe training for your team. We have really, really comprehensive services we're available to help you. And we also have our HR Assist program that we're really excited about. So if you need maybe someone to come on site and do your day-to-day HR operations, we have a team of trained experts that can help you out with that. You can have a dedicated person that has the benefit of working with CEA and our team. And it can be a really great option if you're trying to get your HR department really off of the ground and develop it, or you maybe have your HR person that's out on a leave of absence, maybe out on a pregnancy disability leave, right? And you need someone to kind of temporarily step in and help you out. We have a lot of different options, so we have a link to our flyer there if you're interested in learning more about that. And then I want to remind you about your webinars that are provided by Monterey County Works. So the next one that's coming up looks like it's on Wednesday, August 14th, and that is Harmony Across Generations. So be sure to register for that and join us again. And with that, Anna, I think I can turn it over back to you. Astrid, do we have any outstanding questions we should answer?
So there was one that came up that might benefit everybody. It's regarding exempt employees. So going back to exempt hourly employees and hourly employees who earn vacation PTO per hours worked versus an exempt employee who's requesting to be paid because they're working over, above and beyond. You know, they're an exempt employee, which means we're not tracking their hours, but the employee is claiming, look, I come in on Saturdays, I do extra trainings. My coworker who's an hourly is earning PTO based on hours worked. Do I get that benefit? How would you respond to that employee? I think that's a
So
great
with
question.
what tied to PTO?
Tied to PTO and yeah, earning it based on hours worked. So yeah, the
Yeah,
exempt employees, it works differently because
yeah.
they're
They earn
not
it uniformly.
uniformly.
So if you do have somebody going above and beyond, I think a better approach would be a bonus. So assessing whether, you can maybe have a performance review and assess at that time, do we want to offer this person a bonus for going above and beyond, or do we just need to increase their salary level? We don't want to lose them. It's kind of just a negotiation. So luckily, we don't have as many compliance issues with exempt employees, but still they do earn PTO uniformly. So I wouldn't recommend tying it to hours work because that starts to make them look more like an hourly.
Yeah, I think it's more of a morale issue for that exempt employee. So I like
Mhm.
that idea. Or maybe having a
Or
different
upping their
accrual.
vacation.
Yeah, upping
Right.
you can have a non-exempt employees accrue this way, exempt employees accrue that way. Something like that, Juliana, or just
Yeah, that's
increasing
probably the
that.
simple solution is just increasing their yearly cap on what they earn so they will earn it at a faster rate, not based on hours worked. So I think that would be probably a simple solution to that. Great
Yeah.
question.
Yep. Thank you, everybody. I think you answered everything else. Thank you.
All right, perfect. Back to you, Anna.
I am continually impressed every single training, especially these really big, meaty compliance trainings, how much you manage to pack into literally less than an hour and manage to get everyone's question answered. So thank you both for sharing your expertise and your energy with us today, Juliana and Astrid. Thank you, Pearl and Laura, and your entire team at Monterey behind the scenes for bringing all these resources to these employer. Pearl, I know we weren't able to let you speak at the beginning. Did you have anything final to share with everyone today?
My apologies, I was muted. Really quick, I just wanted to remind everyone regarding our free recruitment videos that we have for the any employers that's hiring. It really allows us to assist the business in putting it out there. If they are hiring for any positions, our HR hotline. Any questions to make sure they take advantage at no cost. If they have if they need any support, I will write the number on the chat room unless Anna, you can bring up that flyer that we share. And then our meeting rooms are available also at our facility from 8 a.m. to 5 p.m. I will write the HR hotline number here in case anybody is interested. We highly encourage for you to call. Again, it's at no cost to really support businesses out there. And if you guys have any questions, you guys can reach out to Laura. And I will put my contact information here on the chat line also. Thank you.
Awesome. Thank you, Pearl, for attending today. Thank you for getting everyone here live and for continuing to provide Monterey County with such amazing resources. If you are joining us for continuing education credits, I'm putting that in the chat. You'll also see it on the screen, 666739, SHRM code 24-VYGRK. For any reason you have some trouble redeeming those, please just shoot us an email, ceainfo@employers.org. We will make sure that you get those credits. And so with that, thank you again to Monterey County for sponsoring today. Thank you, Juliana and Astrid, for sharing your time and expertise. And thank you all, especially for joining us live. And we hope to see you at that next training in August. Cheers.